Freedom of Assembly, Articles 19, 1b and 19, 3. Article 19, 1b guarantees to all citizens of India right to assemble peaceably and without arms. The right of assembly includes the right to hold meetings and to take out processions. This right is, however, subject to the following restrictions. 1. The assembly must be peaceable. 2. It must be unarmed. 3. Reasonable restrictions can be imposed under Clause 3 of Article 19. The right of assembly is implied in the very idea of the democratic government. The right of assembly thus includes right to hold meetings and to take out processions. This right, like other individual rights, is not absolute but restrictive. The assembly must be non-violent and must not cause any breach of public peace. If the assembly is disorderly or riotous, then it is not protected under Article 19, 1b, and reasonable restrictions may be imposed under Clause 3 of Article 19 in the interests of sovereignty and integrity of India or public order. When a lawful assembly becomes unlawful, Article 19, 1b saves existing Indian law regulating public meetings in the interest of public order if the restrictions are reasonable. If an assembly becomes unlawful, it can be dispersed. Chapter 8 of the Indian Penal Code lays down the conditions when an assembly becomes unlawful. Under Section 141 of the Indian Penal Code, an assembly of 5 or more persons becomes an unlawful assembly if the common object of the persons composing assembly is a. To resist the execution of any law or legal process. b. To commit any mischief or criminal trespass. c. Obtaining possession of any property by force. d. To compel a person to do what he is not legally bound to do or omit which he is legally entitled to do. e. To overawe the government by means of criminal force or show of criminal force or any public servant in the exercise of his lawful powers. An assembly which was not unlawful when assembled may subsequently become unlawful if it becomes violent or is likely to result in disturbance. Under Section 129 of the Criminal Procedure Code, 1973, such an assembly may be ordered to be dispersed if the disturbance to the public peace is reasonably apprehended. Section 151 of the Indian Penal Code makes it an offence not to disperse after a lawful command to disperse has been given. Section 107 of the Criminal Procedure Code empowers magistrate to obtain security for keeping the peace from any person who is likely to commit a breach of peace. Section 144, Criminal Procedure Code, 1973 empowers the magistrate to restrain an assembly, meeting or procession if there is a risk of obstruction, annoyance or injury to any person lawfully employed or danger to human life, health or safety or a disturbance of the public tranquility or a riot or any affray. The Police Act 1861 empowers a public officer to direct the conduct and prescribe the route and time of all assemblies and processions in the interest of public order. Under Section 30 of this Act, a prior license has to be taken by member of the public to take out a procession. A law conferring authority on the magistrate to grant or refuse a license to hold a meeting or a law imposing a restriction that no public procession could be taken out without a license from a magistrate has been held to be valid. Unlike the American Constitution, which guarantees to the people the right to keep and bear arms, the Indian Constitution does not guarantee any general right to carry arms to any assembly, lawful. However, the existing Arms Act prohibits possession and carrying of unlicensed offensive weapons. The Prevention of Seditious Meeting Act, 1911, prohibits public meeting likely to promote sedition or to cause a disturbance of public tranquility. It empowers the state government to declare the whole or any part of the state to be a proclaimed area. Thereupon, no public meeting for the furtherance or discussion of any subject likely to cause disturbance for the excitement, or for the exhibition or distribution of any writing or printed matter relating to any such subject, shall be held in any such proclaimed area, unless written notice of the intention to hold such meeting and of the time and place of such meeting has been given to the district magistrate or the commissioner of police, as the case may be, at least 3 days previously. B. Unless permission to hold such meeting has been obtained in writing from the above officers, as the case may be. All the above-mentioned statutory provisions impose reasonable restrictions under Clause 3 of Article 19 on the right to freedom of assembly.